What are the four main questions the Court of Appeal should ask counsel in a Section 68 leave application under the Courts of Judicature Act? Imagine standing before the three judges of the Court of Appeal hoping to unlock the door to a higher hearing. What are the stakes? Your case involves less than 250,000 ringgit as damages. So, under Section 68 of the Courts of Judicature Act, you need the court's permission, called leave, before you may proceed. The panel turns to counsel and says, you have 10 minutes. Please address the court on 4 questions, succinctly, precisely, and clearly. What are your key questions on appeal? So therefore, strip down your case to its core, outline the specific issues you want reconsidered. Is it a single glaring error or several? Don't waste time on a ramble. Distill your grounds to clear, pointed questions. Question 2. Are your issues you're raising now questions of fact, law, or mixed questions of fact and law? This is critical. We have done a video on this before. I suggest you see it. Appeals rarely succeed on fact alone. The court wants to know, are you challenging findings of fact, fundamental points of the law or its application, or the grey area where both collide? A pure question of law, of course, usually stands a better chance. A mixed question where law and facts intertwine and collide must show error on both sides. Question 3. Can you show which of your questions pass what's known as the Danga Bay test? That is to say, prima facie test. That your appeal is not useless, frivolous. Here, you must clear the modern hurdle shaped by the Court of Appeal in Country Garden, Danga Bay, and Berhad. Show the court that your appeal has a real prospect, however modest it is. It need not guarantee victory. Show a prospect. It must only rise above wasting the court's time. Frivolous, after all, is a legal shorthand for doomed from the start. Question number 4, the judge will ask you, explain exactly how you meet the Danga Bay threshold. This is your proving ground. Walk the panel through your best points and connect them directly to the Section 68 prima facie test. Is your question neither trivial nor hopeless is what you have to show. If so, then show how your case isn't obviously unsustainable. Rehearse your strongest arguments with clarity, not volume. Why these 4 questions? Why this sharp, short, precise format? Consider the history. Judges have long debated how high to place the leave barrier. Mr. Justice Edgar Joseph Jr., as he then was, once urged a 3-limb test. Prima facie error, novel principle of public importance. These echoed from English precedents, yet this approach simply raised the bar too high, especially for those with limited means. In practice, it risked closing the door to the less wealthy while letting the big money cases sail through to appeal. So the Pachi in the kampong, who's just had a $100,000 appeal, will stand no chance. That we cannot allow to happen. That's why came the Danga Bay decision. The Court of Appeal recentered the test. It said the leave process must filter out frivolous or unmeritorious appeals, not every small claim. This marks a real democratization of justice. So the real task of the Court of Appeal is not to see who can leave the highest, but who can present a case worth the court's attention. So the test is very low. Even so, frivolous and unmeritorious are not twins. Frivolous means obviously unsustainable or wholly indefensible, a very low bar. Unmeritorious means a lack of prospects, a test very perilously close to arguing the entire appeal at the leave stage. What's the effect? Appeals over 250,000 ringgit need no leave, no threshold at all, even if they are useless cases, while smaller appeals, even if meritorious, must undergo this extra scrutiny. This mustn't translate into discrimination. That is why the threshold must remain as low as fairness allows. In reality, most Section 68 leave applications are granted unless the matter is so hopeless or so lacking in substance that no reasonable court could countenance it. The words obviously unsustainable come from the old English case, if you remember, Attorney General of Duchy of Lancaster versus London and North Western Railway, 1892, hundreds of years ago, still ring true, echoed in the federal court's own definition of frivolous. The true purpose, therefore, is to keep out appeals that would waste time, not those that have an arguable, however small the basis. In summary, the four-question framework forces discipline and clarity. First, it compels counsel to cut to the chase. Second, it helps the court instantly gauge whether a real live issue, even on a 10,000 matter, 20,000 matter, lies within the appeal. Third, it ties directly to the principle cemented in the Danga Bay case, focusing on excess, fairness, and judicial efficiency. A leaf filter is not a fortress, it's a sieve. It's there to catch only the most hopeless cases, not everyday Malaysians with real grievances. I hope that made sense. Have a good day. Goodbye.